Hello everyone. In this video, I am going to explain the Corrazin v. Edward Jones brief. And doing so, I'm going to hope I can get you more familiar with case briefing and perhaps get you a little more comfortable with some of the issues you may struggle. After you watch this video, you will have the opportunity to brief another case for extra credit. So if you hadn't already, you need to make sure that you're following the case brief format that's attached to every case. And it will have all the categories listed for you that you need to make sure you go through. We're going to do that for the Edward Jones case now. What I want you to first keep in mind is that when we have a brief, what we're doing is we're taking an opinion, that's what we call them, from a higher court, some kind of appellate court, and we are trying to put it into a format that we can refer to and easily determine what happened in the case, where it happened along the way, and most important, applying facts in your reasoning to the rule of law. So let's first talk about the first two facts and procedural history. The procedural history is going to be have the parties, how did they get involved in a legal dispute in the first place? I'm sorry, that's the fact. Sorry. The procedural history is what courts have heard this case and what happened at those courts. Now, we're always going to start at a trial court level. Okay, so you're always going to have somebody sued somebody in a trial court. We won't be doing any criminal cases, so you always have so-and-so sued so-and-so in trial court. And that's going to be your first line of your procedural history. But then what happened in the trial court and who appealed after that and where did they appeal to? Remember, if we're at the Court of Appeals, generally speaking, we're only going to that means that somebody didn't like the decision that the trial court made and the judge made. Remember, appeals are about what decisions that judges have made prior to the case getting to the court before it. And you're arguing, the appellant's always arguing, wait a second, the judge messed up and I don't like what happened to the case because of that. Okay, so let's say I'm doing something really unreasonable and I'm acting unreasonably and I somehow bump into you. And so you sue me for negligence. And I look at myself, I come to myself and I say, well, wow, how can I be sued for negligence? I asked them, were they hurt? They said no, everything was fine, and now I have this paperwork. So I do my discovery. Remember, we talked about discovery, and I do my request for admissions, and I want to know how you were harmed because, as you know, in a negligence case, you have to show that I not only had a duty to do something or not to do something, that I breached that duty, and that I caused harm. And along the way, I find out there is no harm. So I'm going to file a motion for summary judgment. And remember, that's the motion that says this isn't even going to get to the jury. We don't have even enough facts for you to prove all of your claim. Okay? So what we call that is if there are there's a genuine issue over the material facts on each of the elements, we'll move it forward to the jury because they're the ones that are going to decide how the facts should apply. Okay, so I do all this and you have nothing, and I file this motion for summary judgment. You respond, and there's no harm. So I filed this with the court, and the trial court judge says, we're not moving forward. I'm going to grant this. You are not going to like that decision, so you're going to appeal. And when you appeal, the appellate court's going to form an opinion. Okay? So the appellant is going to be the one who has lost a claim. They're not happy with it because they believe the judge should have never made that ruling. Maybe you're trying to argue, I don't need to cause direct harm. You know, maybe something that it doesn't really even make sense, but you want to argue it anyway, okay? We, in our procedure history, are always going to look at where it started, what the court did, and then where it was appealed after that. So let's take a look at this case. When we look at the case, the first thing we want to do is look to the very first court you see in the Court of Appeals of the State of Kansas. That means this is the opinion that we are briefing, okay? In this case, they tell us right away where the appeal is. It's from Johnson County or Johnson District Court. What does that mean? That means they're telling me right there that the lawsuit was filed because it's district court, and now I know it's before the Court of Appeals. Okay, so that's part of my procedural history. So then I'm going to read through and I'm going to see we have some facts here, right? We have the facts that Corrazin went to Edward Jones, and in a nutshell, he fell, the chair broke, he fell, he sustained harm, and he's saying that Edward Jones had a duty to them. And what was the duty? We will find out in the facts that the duty was basically to say, hey, you need to let me know that this chair was not for this use, okay? But before we get there, we're reading through and we see that Corrazin sues Edward Jones, okay? They filed the negligence action, Corrazin did. And this is where they get all the discovery and they go, wait a second, there's really no genuine issue of material fact regarding we owed you a duty to do anything, okay? Sure, you were harmed by the chair that was broken, but what did we do to cause that harm? Now, the trial court agreed, right? The trial court said, you know what, we're going to grant summary judgment for Edward Jones. So when the trial court agreed, Corrazin says, I don't like that, I'm going to an appeal. This is what, and these are a continuation of effects. This is how our procedural history will look. You may want to take this down before I fill in the blanks. You can even take a picture because this is kind of your guide. You're always going to have somebody who sues somebody in a court, right? So in this case, we've got Guy Corrazin sues who? Edward Jones in Johnson County District Court, okay? Then we want to know what that court, Johnson County District Court, did. So you put in that court, and you're going to explain what they did. In this case, they entered summary judgment in favor of Edward Jones, right? So once they entered summary judgment, what happened? Somebody appealed, Guy, because it was in favor of Edward Jones. Guy appeals, and then where is it? The Kansas Court of Appeals. Now, if our case was before the Supreme Court, then we would have to put what the Kansas Court of Appeals did at that level, and then say someone appealed to the Supreme Court. But we don't have to do that because what? The case is now before the Kansas Court of Appeals, and that's our procedural history, okay? Our facts are what I told you they were. They led us to why we were there. So when we look at our rule of law and our analysis, what we're going to look at is what is the appellant? What does the person who is taking you to court, to the appellate court, the appellant, what is that person saying the court did wrong? And in this case, Corrazin said that the summary judgment's improper because I presented evidence that should have went to the jury that said, hey, they had a warning. And that's enough evidence that they should have, that the chairs had a warning. So that's enough evidence to show that Edward Jones had a duty to us. Okay, so we did have evidence that we could have put before the jury and said, listen, they had warning tags, and those warning tags should have put them on notice, which they should have put us. Okay, and then we're going to see that the court of the rule of law. But before we look at that, what we want to do is look at the issue. So what is, and ignore that last line for a second, I'm sorry, it shouldn't be in there yet, but what is the plaintiff arguing? Well, the issue is really whether the trial court erred when it blank. So put whether the trial court when it erred when it what? Granted summary judgment in favor, but that's not enough. What did they say? Why did they grant it? Well, in this case, they ruled that placing residential grade furniture in a commercial setting was not enough evidence to present a genuine issue of whether they were negligent or whether they owed a duty, okay? And then the holding, and sorry about my arrows and everything, they're out of whack, but the holding is just going to be yes or no to this issue. And in this case, no, the trial court did not err. What does that mean? The Court of Appeals said that's not enough evidence to move forward and say that there's this material issue of whether they were negligent. There's not enough, right? So how do we know the answer is no? Go to your disposition. In the beginning, we already know that they said they affirmed the decision, but if you go to the very end, you're going to see that and it's going to be, what court are you before? Kansas Court of Appeals. And these are going to be your options: affirmed, reversed and remanded. Generally speaking, sometimes you'll have vacated. Those are mostly what you're going to have. And who did the decision of who? Well, we already know the trial, Johnson County District Court. That's our disposition. Well, we know they affirmed, so we would choose affirmed. So our disposition would read, the Kansas Court of Appeals affirmed the decision of the Johnson County District Court. When you affirm the court, you mean, what you're doing is you're saying, we approve what you said and you did not err. So that's how you know automatically, okay? So then let's keep going. Here's our rule of law. Now we talked about, there was on the one page, there was a little rule of law, but really the rule of law here is to establish negligence, the existence of a duty. The plaintiff must show that the owner or operator had actual knowledge of the condition, or that the condition existed for long enough that in the exercise of reasonable care, the owner should have known the condition. If no duty exists, no negligence. That's our rule of law. So you have to word it in your own words. And basically you can say, hey, negligence requires that there is a duty. And in order to argue that a plaintiff has a duty to warn about potential harm, that the owner operator has to have either actual knowledge, or there has to be a condition that exists so long that they would have known if they would have taken reasonable care. That's our rule of law. So that's what the law says. So what's the reasoning? So in this case, we have to take the facts. Reasoning is always applying facts to law. Facts to law is the reasoning. The reasoning in this case is, what did we have to show that they had actual knowledge? Well, the only thing that the plaintiff is arguing is, well, they had actual knowledge because there was a tag on there and it said for commercial use only. And then they looked more and said they didn't have any evidence that the chair was used for a long period of time. In fact, it was for a short time. And in fact, there was deposition testimony by the plaintiff, and he said, hey, if I thought there was something wrong, I would have chosen a different chair, but I didn't even think there was anything wrong. So the question is, when we look at those facts and we apply the law, is that enough to move to the jury to say that they had a duty? And the court looks and says, you know what? No, it's not enough. So what they reasoned is basically that it is not enough to have just a warning chair or warning label, or it's not even enough just to put a residential grade furniture into use for commercial use. Just the mere fact of me putting something that says residential use and I use it for commercial is not enough to make me warn you that something may happen. I have to know that there's something going to happen, or that something's in such condition that I should have reasonably known. And they said they didn't. Okay, and that's the reasoning in this case. So at the end of the day, what do they do? Again, we go back to your disposition, and they affirmed. And who's we? The Court of Appeals. So this in a nutshell is how you walk through your brief, okay? You want to remember, here is the kicker. Your issue is never going to be whether someone's negligent or not. It is never going to be whether someone is liable or not. Those are facts that you apply to the law, and you have to determine those facts, the application of those facts to law through the fact finder. However, if you don't have enough facts to start with, the court can kick the case and say, we don't even want to go this here. But they're not. What they're saying is, yes, in a way, we affirm, so that means you're not going to be liable. We're going to dismiss the case. But we're really not discussing liability. What we're discussing is whether or not you had enough evidence to even move forward. I hope this helps, and I hope you all take advantage of the extra credit opportunity. If you have any questions, please feel free to call me. One last thing is your briefs always have to be in your own words. A copy and paste brief is no brief at all. You just copy and paste sections. I don't know if you know what that even means. So make sure that you're using your own words. Thanks again.